At the A4ID Socio-Economic Rights event on Monday the 16th of July 2012, Patrick Geary of the Child Rights International Network delivered a talk on the Convention of the Rights of the Child, and more specifically on the complaints mechanism in place to deal with the failures of the Convention.
Okay, so I will be talking about the new complaints mechanism that now accompanies the Convention on the Rights of the Child. Unfortunately, as this is not actually in operation, it will probably not be as exciting as the last presentation you've just heard, but I'll do my best to sort of frame things. So to put this all in context, talking about the UN treaty bodies. So each major international human rights treaty has a corresponding treaty body that's composed of independent experts. So some of the conventions that Ashley mentioned, like the Convention on the Elimination of Discrimination Against Women, the International Covenant on Economic, Social, and Cultural Rights, those will all have treaty bodies that accompany them, usually called committees. They're supported by the Office of the High Commissioner for Human Rights in Geneva, and along with other bodies like the Human Rights Council, they're tasked with promoting and monitoring human rights within the UN. When a country ratifies a treaty, it becomes a state party to that treaty, and it assumes legal obligations to implement the rights in that treaty. Two of the essential treaty body functions are engaging with states during the reporting process to assess implementation. So what happens here is when a country ratifies a treaty, it will file a report saying this is how our laws comply or don't comply with this treaty. They'll then go to Geneva, they'll have an interaction with the treaty body, so the committee will then say, yes, this law is great, this law needs some work, and they'll issue concluding observations and recommendations. And the Committee on the Rights of the Child, which is the body associated with the Convention on the Rights of the Child, has been doing this for a number of years now, I think decades. And the second function, which is more the focus of tonight, is that these treaty bodies adjudicate complaints from individuals, groups, or their representatives who are claiming violations of their rights. So the Committee on the Rights of the Child is as I said, it's the treaty body associated with the Convention on the Rights of the Child. It's made up of 18 experts who meet in Geneva 3 times a year to examine state reports. It will hear the complaint submitted under the new optional protocol, which was the instrument that created the new complaints mechanism. They are currently drafting the rules of procedure for the complaints mechanism, which we'll talk about a little bit more later on. So I thought it'd be helpful to give some of the background of why we need a CRC complaints mechanism in the first place. One reason, plain and simple, is that for a long time it was a matter of discrimination against children. The CRC was the only treaty that had a mandatory reporting procedure, which is what I was talking about, where the government will sort of interact with the committee to talk about their laws, without having a complaints mechanism to accompany it. Another important thing is that other mechanisms, so the other treaties and the other treaty bodies that look at those treaties, don't really cover the full range of detail or rights in the CRC. And we also thought it was important that complaints by or on behalf of children be considered by a committee with special expertise on children's rights. So the complaints mechanism campaign. So for these reasons, a campaign was started in 2000 by the German NGO Kindernothilfe. The first meeting of a growing NGO coalition, as things really got going, happened with the Committee on the Rights of the Child in fall of 2007, and this was endorsed by the committee in spring of 2008. And here's a great example of some UN language for you. In December 2009, a working group was established to explore the possibility of elaborating an optional protocol, which is sort of the first step in actually drafting the protocol and then it eventually coming into existence. So the working group was given the go-ahead to draft the complaints mechanism in 2010. Negotiations were held in Geneva in late 2010 and early 2011. A draft was submitted and adopted by the Human Rights Council in spring 2011, and the optional protocol adopted by the General Assembly in December 2011 is what we now have in place. And there weren't many changes from the negotiation stage. Once things had been finalized by the chair, things have basically stayed the same. So when can you start complaining? It was open for signature in February, and it'll come into force when the 10th state has ratified. So far, 23 states have signed, but none of them have completed the ratification process. Usually that does take some time, but I think it's hoped that soon, maybe before the end of the year even, that the new optional protocol will come into force. So some of the requirements in general to file a complaint. The first is that there has to be a specific identified victim or a group of victims, so you can't submit complaints anonymously. One of the things that was actually discussed during the negotiations was the idea of a collective complaint, whereby a complaint would be able to be submitted to the committee to say that there is evidence that, for instance, the right to survival in a particular country is being violated because children aren't getting the food or nutrition that they need. And just looking at general information and statistics, the committee would then be able to review this and say, this is a violation of children's rights. Unfortunately, that didn't make it through into the final version. So as it stands now, much like bringing a court case here, you do have to actually identify a specific victim or a group of victims in order to bring a case. Second is the complaint has to allege a violation of the CRC by a state that has ratified the optional protocol. So the state will actually, again, have to accept the jurisdiction of this new complaints mechanism. Third point, effective domestic remedies must be exhausted. So, again, there is a proviso that if the domestic remedies aren't effective because of lack of independence in the judiciary, corruption, or sometimes even time delays, if it's going to take 10 years to go all the way through the court system, especially when you're looking at a child's rights, that might not be considered an effective remedy. But to the extent that there are effective domestic remedies, they would have to be pursued on a national level before you could complain to the Committee on the Rights of the Child. Fourth, the complaint must be submitted within 1 year of the exhaustion of these domestic remedies. Again, this was a matter of discussion that came up during negotiations. This isn't included in all of the complaints mechanisms that are overseen by the UN treaty bodies. And it was felt that it shouldn't be included in this one, and in particular maybe that there should be a chance for children, once they've turned 18, a certain amount of time after that for children to pursue those remedies. But unfortunately, as it stood, we ended up getting a 1-year limit. And the fifth point here is that the case cannot already be under consideration by another international complaints mechanism. So you can't go to one committee and then later try to go to the Committee on the Rights of the Child. So how is this mechanism different from some of the other complaints mechanisms on the UN level? First, the committee has to follow the best interests of the child and to keep in mind children's rights and also the views of children. Second, the rules of procedure that are now being drafted, the committee has been instructed to make them child-sensitive. So I guess it remains to be seen how exactly this will be borne out, but this is not something that's been included in other optional protocols. So these will be specifically tailored with the idea that we will be looking at children's rights. The committee has also been instructed to introduce safeguards to prevent the manipulation of children, and can decline to accept complaints when these complaints don't appear to be in a child's best interests. So some examples I think of this might be if you had one parent who wanted to use a complaints mechanism to gain custody and to sort of exact revenge on another parent. Some of the sorts of things that you might see played out in national courts on that level, I think, was a concern during the negotiations, that children might be sort of used to bring complaints to serve other people's means. Another thing about the mechanism is that the identity of child victims will be kept confidential, so it won't be anonymous. The state that you're complaining against will know who is bringing the complaint, but it also won't be revealed publicly without the child's consent. And speaking of consent, you have to have the consent of a child to bring a complaint unless you can justify acting without that consent. So if the child had a severe intellectual disability, or the child was institutionalized or unable otherwise to bring this complaint themselves, or to give you consent to bring the complaint, you might be able to proceed. So what kinds of complaints could be brought? So I thought it might be helpful here to go through some examples involving children that have been addressed by other treaty body complaints mechanisms. One here, a mother and a daughter in Sweden avoided deportation to the Democratic Republic of Congo, given the high risk of torture and sexual violence there. Here in Libya, a man was arrested, and his wife and children brought this case, and it was found that their rights were violated given the anguish that they suffered and the limited information that they were given throughout the detention of this man. Following the torture and murder of 7 people, including a 16-year-old, by military forces in Colombia, a treaty body found violations of rights to life, liberty, and private life. In Greece, families evicted from a Roma settlement established violations of rights to privacy, family, home, and special protection. A 15-year-old indigenous victim of sexual assault in Argentina brought to light discrimination and degrading treatment during her case's examination and the investigation that ensued. In Norway, students and their parents challenged a mandatory Christian education subject in public schools as a violation of their right to freedom of religion. In Tajikistan, 5 people, including 2 children, who were arbitrarily arrested, tortured, tried, and detained by authorities in violation of their rights. A case was filed, and the treaty body noted that the special rights and protections should be provided to children. And a woman in Bulgaria victimized by domestic abuse had her rights violated when the courts refused to put in place a permanent protection order and failed to provide shelters for her and her children. So as you can see, they kind of run the gamut of all different rights and from all different places around the world. And that's sort of what we would hope would actually happen when the CRC complaints mechanism comes into play. Since the Convention on the Rights of the Child covers a wide range of rights and is so universally ratified, we're hoping that the optional protocol will enjoy the same sort of acceptance, and that you'll see a similar spread of cases that are more specifically targeted around children's rights. So things to consider when actually thinking about filing a complaint. First off, there's no legal assistance provided at the international level. There isn't for any of the other treaty body mechanisms. There isn't likely to be for this mechanism either. There may be, in some cases, national systems that will provide legal aid to challenge a national law or a procedure or actions all the way up to the international level. I know at some point those did exist in the Netherlands, but I don't think they're particularly widespread. So it's unlikely that there would be legal assistance provided or funds granted. Complaints must directly involve specific child victims who cannot remain anonymous. So again, I've said this before, but something that's important to remember when you're thinking about bringing a case that involves a child before an international body is that the child will be identified and will be made known to the state. Again, complaints can only be brought against states who are willing to accept them. So very important that the optional protocol enjoys wide ratification or it won't be of too much use. The proceedings themselves are conducted mainly on paper. It's not sort of like a national trial where you would be bringing a child to Geneva and putting the child on the witness stand. It tends to be much more oriented around submissions. And one worry is that there's no teeth to committee decisions. So the committee will issue decisions and will send those to the states. And there are some methods by which the committee can follow up and ask for more information and ask a state that has been found to violate a child's right what have you actually done here? How have you solved this problem? But ultimately, if the state says, we haven't done too much, or we've done this and we think that's enough, there's no hard enforcement mechanism. The committee can't show up and, attach assets in a jurisdiction or free a child from detention. But this isn't to say that you shouldn't use it. I think that the right to remedy is a necessary component of all other rights, and if you don't have a way to enforce the rights that are set out in international law, they're not of particular use. And despite the weaknesses of the UN treaty body system, we do now have a special complaints mechanism that is designed with children in mind. And there are lots of family and children and juvenile courts in operation around the world that are designed with children in mind. But this is unique because it's a way for children to bring complaints and sort of a way to draw attention to violations of their rights. So it's really enhancing children's access to justice on that level in a way that hasn't really been done before, certainly on the international level. And this will also give the committee an opportunity to create a children's rights jurisprudence to interpret rights of the convention and to draw attention to violations. So this will be sort of a way for the Convention on the Rights of the Child to stay current and to stay relevant as a legal instrument, and to see how it can actually be used to look at violations of children's rights on the ground. But, of course, the complaints mechanism is only meaningful if children and advocates actually use it. So once it actually comes into place, and hopefully the UK will ratify it, it would be wonderful to see it getting a lot of use and a lot of attention, and to really see how it can enhance access to justice for children. So I think that sort of covers the overall sense of it. I do also have a handout that I'll put in the back that just sort of runs through some of the basics of treaty body mechanisms and some of the specifics of what I covered. And thanks for listening.